Okay, so let's do the discussion part of the class. The first thing is to look at the YouTube video I put up yesterday. It was about a 20-minute W5 CTV television piece on the use of mefloquine in the Canadian Armed Forces from the 1990s to relatively recently, with respect to its use in both action in Africa and Afghanistan. So it deals with a mass tort, and mass torts are what we're talking about tonight. Mass torts are slightly different than class actions, and we'll talk about that distinction. So the second part of the lecture tonight deals specifically with this kind of lawsuit. Now, the mefloquine issue is not necessarily an environmental law issue, but there are lots of environmental law issues, mostly in the United States, that deals with things that affect the environment that are mass torts. The BP oil spill in the Gulf of Mexico, which affected tens of thousands of people. That was an environmental mass tort, and I have a short video of that for you at the end of the class. So I wanted to use a Canadian example of a mass tort. So it really doesn't matter what the cause of it is. The whole idea, obviously, is that it causes a massive amount of damage to a mass number of people. All right, and that's what makes it a mass tort. So any comments about it from anybody? Georgia?
Yeah, well, I was just wondering if there are other drugs for malaria. Like they said in other countries, like Australia never used it, and lots of other countries aren't using it. Then why is Canada still using it, and why don't they just take it off the market?
Yeah, there are. I've been to Africa. I've taken antimalarial drugs. It wasn't mefloquine, thank God. So yes, there are other examples. The reason they were used, in the Canadian Forces is that it wasn't something that had to be supplied to everybody on a daily basis. It was a once a week kind of drug, but because it was so simple to take, it just made it administratively more simple to basically give it to everybody who was serving at the time. But yeah, there are other antimalarial drugs, and Australia, I'm sure, uses them because they have people who are in the armed forces that go into the Philippines and in Asia, and they also go to Afghanistan as well. So I mean, so obviously they've got another kind of drug that isn't mefloquine. So and other nations too. I mean, we use it on what's called a last resort basis now. So obviously there's some other kind of antimalarial drug that's being used as the drug of first choice, not last resort. But yeah, I mean, it's still being used in those remote circumstances. Anybody else? Nobody has no other comments on this?
I'll take one, Miles.
Well, Miles.
Go for it.
Yeah, I'm thinking.
Miles,
Hang on, Pete. Let Rhett go first. Pete, go to you. All right.
Okay. Yeah. I'm thinking it's so strange how the armed forces would have institute the use of this drug, and the soldiers not knowing that they're part of a selected group or a trial group, and that's just concerning or disheartening as to how they would treat soldiers like that. But why hasn't this gotten more traction, or we haven't heard about this in the mainstream media? Like, this is the first time I'm hearing about this on this video, which I'm wondering why not, right? And then when the government shut down the inquiry into the use of drug, it seems as if there's some sort of cover-up or corruption from the highest level. How confident you are that this case will even go further? Because it seems like it's been knocking around for a while, but has not gotten the needed traction to hold the government to account.
Yeah, good points. I mean, it's being litigated now. So, and we saw the lawyer, I think his name was Miller, I'm not sure, but we saw it in the videos. So it's being litigated right now. So it takes years for especially complicated lawsuits to go through the system. We also saw in this W5 piece that it had a previous W5 piece or a CTV news piece in the late 1990s on this issue. But having said that, I mean, you're absolutely right. This is the first time that I actually paid attention to this when I was looking for a mass tort that was Canadian that I could show you guys. So, I didn't know anything about this beforehand, and I've got a lot of connections with the armed forces. So, but I can tell you that there is a psychology to the armed forces that has been around for as long as there's been armed forces. So it's been around for centuries. And the psychology is, to a great degree, the people who belong to the forces are there full time, and they're there to take orders. And they've almost always been seen as property and not people, right? They're numbers. They're serial numbers on their identification tags. Canadians use identification tags like these. Americans use dog tags. So it's been around a long time. The way that the power, the upper echelon of armed forces treats the men. For instance, one of the biggest mass torts, and it involved tens of thousands of people, was the use of Agent Orange during the Vietnamese War. Right, Agent Orange was a defoliant agent. It was the whole thing about one of the things, and the reason the Americans lost the war to a great degree, is that it was a jungle war. And so Agent Orange was used to defoliate the jungle, as in, they drop it on everybody. If you're on the ground, you're going to be subjected to it, to kill all the jungle, essentially. And the thought behind that is that once you took away the cover for the Viet Cong, that they'd be more obviously open for being taken out. So that was a monumental mass tort, that because Agent Orange, was a toxic substance, and it caused enormous amounts of damage to the Vietnamese veterans, especially to their lungs. So and they dropped it without any regard to the safety of the men, right? It was more important to win the war than it was to make sure that you weren't harming your own men and women in the field, right? And that's been the way that the British Army, when it was the biggest army in the world for centuries, treated its men as well. So anyway, but getting back to Rick's question, why is this something we haven't heard of in the public, in the last 20 years so much? I honestly don't know. I mean, I really don't. I mean, I know that, again, apart from the litigation that's still going on, I don't know why it hasn't been more publicized, right? So, Valerie, you have your hand up?
Yeah, I was wondering where the accountability was towards the producers of the drug to monitor the long-term effects.
Well, and they mentioned it in the piece, whoever the manufacturer was, Roche, somebody, they weren't sued in the mass tort because they like every other drug that's out in the public that's been approved for public consumption, they in fact do put on their packaging, here are the possible side effects of this drug, both short-term and long-term. So, if they're approved, they're not going to be liable. That's just the way torts work. So as was the case in this particular lawsuit, the liability goes to the armed forces itself and the Canadian government, who obviously the armed forces are part of. So they're the ones that use this to the detriment of the men and women in the field. So the pharmaceutical company is off the hook in that regard. Shivani, you got your hand up?
Yes, sir. A quick question though. What was the outcome of the case though? Was there any damages rewarded?
Which case?
With the whole because a lawyer was behind the case.
It's still ongoing.
It's still ongoing. Okay.
Yes. Yeah. The W5 piece is a relatively recent one. So yeah, it's there hasn't been an outcome as yet. Tyler.
Hi. Yeah, I was just wanting to clarify what the ground for liability for this litigation was on behalf of the Canadian government. They had mentioned that what the government did was willfully deny and conceal the risks. So would this or would this be considered willful blindness or recklessness on their behalf?
It could be anything. It could be what we spent all last day on. It could be negligence, right? It's a perfectly valid tort. So the armed forces were not careful enough. They certainly had a duty of care to the men and women in the forces. Clearly, there's that link. So they have a duty of care. Then they have to rise above the standard of care, for that duty. And by exposing them to this kind of drug. And they certainly didn't meet the standard of care they should have, which would be prudent for the upper echelon of the armed forces. So, yeah, it could have been negligence. It could be product liability. That's possible as well. We don't talk a lot about that. That's a mass tort often as well. Although that product liability tends to be, again, back to the previous question, something that liability falls to the manufacturer more than anything else. We'll talk a little bit about that tonight. But it's usually the manufacturer that does something that harms people that they don't disclose. So and there's or it could be an intentional tort of some kind. So it could be the intentional tort of assault, right, which is again it's not a criminal charge. It's a tort. So clearly assault and battery is something that is available if the armed forces knowingly knew that they would cause harm to the members of the forces. Lexine? Lexine,
Yeah, so I was.
Sorry?
Yeah, so I was trying to find out is there like any other cases of this, like in Canada or in the world, that could set legal precedent?
All of these cases set precedent. They all have a familiar kind of identity in that it's someone, being the defendant, who causes harm to a large group of people. So that the precedent is more in the procedure than it is in the actual the actual substance itself, because the substances are always different. They have a different effect. So there was multi-billion-dollar settlements in the tobacco industry, for instance, in the last 20 years, because of the harm, to people in smoking, to their lungs and nicotine and what have you, that all that caused that for years and years and years, the tobacco companies denied causing any harm whatsoever, right? So that's the tobacco. There's asbestos, which was a very, very common insulator used in almost every house that was built in the 1920s, 30s, and 50s too, which causes lung damage, right? And the manufacturers of asbestos pretty much all went bankrupt as a function of the mass tort against them, because by the time they got to court, everybody knew that asbestos wasn't a safe product, so they weren't really making that much money, the corporations that manufactured it. And by the time the lawsuit hit them, they didn't have a lot of capital like the oil companies do, for instance, for things like BP oil or what have you. They don't have the capital to draw upon to fall back and pay these things off. So mass torts sometimes drive companies, what used to be very large companies, into bankruptcy. So yeah, there's the precedent as to the procedure, not much of a precedent as to the actual topic itself. I don't know of any other, for instance, lawsuit that involved mefloquine, even though I'm sure it was used in other countries as well. There may be, I just don't know of it. I didn't research that particular point. Pete, you had your hand up. Okay. Anybody else? Shivani, your hand is still up. Do you have another question?
No, sir. I'm so sorry.
That's okay. That's fine. Anybody? Any other comments? I mean, it was a pretty straightforward piece. Everybody could understand what was done, the kind of damage that was done, who it was done to, and what they're trying to do to remedy it. So it's a really good example of how mass torts work. Remember, torts are, as we talked about last day, torts are wrongs in the civil liability context that people that don't have the benefit of environmental statutes and regulations, right? So there's no, for instance, there's no statutory scheme or regulation environmentally that says that mefloquine is banned, that kind of thing. There could be regulations that would ban it for substance, and that would be under the food and drug area of the law, but it's not, because as we saw in the piece, it's been approved for use, and and you can get it cheaply in drugstores. So it's there for use. You just have to, know what you're doing when you take it. Arette, your hands back up.
Yeah. So my question to you, Miles,
Sure.
in this case, what needs to be proven? Because I think it could be a bit difficult, seeing that the experience of war sort of ties into the most of the physical symptoms of this drug, where maybe hallucination or some sort of things that can be associated with PTSD. What needs to be proven in order for this to push forward? I'm thinking that may be one of the challenges these veterans have in putting their case forward.
Yeah, very much so. As a matter of fact, that was mentioned in the video.
Mhm.
The defense that the armed forces would come back with was that, in fact, these damages are a function of PTSD, which already has a separate stream of remedy available to veterans in that regard. So if that was all that was involved, then there would be very little success for this. But as the lawyer for the vets basically said, is that there are a number of symptoms of mefloquine, the long-term uses of mefloquine. There's some of those symptoms that don't mirror what happens for PTSD. So as a function of that, that would be where the defense falls apart, right? If the defense basically says it has to be PTSD, and the experts, the doctors, obviously, basically say that no, that's not the case. That in fact, this particular symptom, whether it's the kind of terror, nightmares they have, or the stomach ache, that the severe stomach aches they have, if those are symptoms that aren't part of PTSD but are symptoms of mefloquine, then that's where the plaintiffs, being the Veteran Association, would hang their hat. Anybody else, guys? Okay, all right, good, thank you, that's great, as usual. All right, so let's go to the lecture. So it's the same PowerPoint as last day, but we've advanced. We've talked about nuisance, gone through all of that. We've talked about tort in negligence, gone through all of that. We didn't touch upon the defenses and remedies for negligence, but I told you can look at that in the PowerPoint yourself. So hopefully you did, to get a full picture of what's involved in the very pervasive tort of negligence. All right, so now we're going to talk about torts that are deemed to be strict liability, and these are very, very common in the environmental context. All right, and there's strict liability because courts over the period of time take the position that we don't care whether you knew or didn't know what you're causing, what the harm you're causing would create some kind of environmental damage. We don't care what your mindset is. It's not a mens rea kind of thing, which you'd find in criminal law. It's not even a careless kind of thing that you find in negligence law. The fact that it just takes place is going to give rise to liability. So that's why it's called strict liability. The only thing that might give a defense with respect to strict liability is that you did everything in your power to ensure that whatever escaped from your property to cause the damage, for instance, that's the Rylands and Fletcher rule, which we'll talk about some more, whatever caused the damage, if you had really done everything that a reasonable person would do in a reasonably foreseeable situation, then you'll avoid liability. But otherwise, you're going to find it's going to be strict liability. And again, it's very, very common in the environmental context. All right. So again, there's really no need to prove that the defendant was guilty. So again, no intentional or negligent conduct in that regard. Right. So in the absence of defenses, all the defendant has to be shown is that the defendant caused the loss, right, sufficient to impose liability. So that's a very general rule of it, basically. Historically, the evolution of the common law, remember I touched upon this last day when I said, for instance, that negligence was a relatively recent tort, only came into being in the last part of the 19th century. For the most part, strict liability has been around quite a bit. It tied into fault liability over the course of time as tort law developed, basically. But when it moved into fault liability, which includes negligence, again, 120 odd years ago kind of thing, 30, 40 years ago, what happened is that those torts that were seen to be strict liability pretty much stopped. The creation of new torts that were strict liability at common law stopped, and they were taken over by things like negligence law. And again, even these torts that were definitely, that stood on their own as torts of strict liability, they've also been eroded to a great degree as a function, again, of negligence, right? You can, if you can prove negligence, right, then you don't have to worry about the advantages of strict liability. All right, so again, we've mentioned this a couple of times, the United Kingdom's House of Lords decision in Rylands and Fletcher, basically. So that's an incredibly important strict liability rule. We also have strict liability rules for things that are caused by fire and damages caused, believe it or not, by dangerous animals. That's a separate kind of strict liability, including trespass. And it's also been encapsulated in what's come to be called vicarious liability, right? Which is basically that, well, anyway, who knows what is vicarious liability? Some of you know this. I know you do. Anybody? If you are vicariously liable for somebody, what does that mean? Okay, so so for instance, employers who have employees that do something wrong, that commit a tort, right? Even though the employer had nothing to do with the tort that was committed by the employee, they are liable for it. So they are vicariously liable for their employee's conduct, right? And so that is a strict liability scenario where you are not at fault for doing anything, whether it's intentional or by carelessness. You just have an employee working for you, but because that employee does work for you, then you are vicariously liable for that damage. Okay. And again, the decline of the number of strict liability torts, basically gave rise to, strict liability being melded into negligence law with respect to standards of care, right? We talked a lot about that last day. So again, standard of care is once somebody is shown to have a duty of care, then the standard of care is at what level should they be held in order not to cause damage, right? So that ties in with the philosophy of strict liability. All right. So to a great degree, torts, strict liability torts that used to be in place for things like motor vehicle accidents, product accidents, and accidents from dangerous activities, which historically, again, were strict liability, they've now evolved into negligence. Okay. We also have strict liability in what has become known as enterprise liability, right? And this is a really important kind of way to look at torts. So what enterprise liability is that if you are in the enterprise of doing something that's large, like manufacturing, railroad, air transportation, nuclear power, those kind of things, right? Then, if something goes wrong, then there's going to be strict liability with respect to that large enterprise, which means the enterprise will become damages for the maybe tens of thousands of people who've been damaged. Okay, so back to Rylands and Fletcher. So the rule in Rylands and Fletcher gave rise to the most significant rule of strict liability in tort law, which is simply this, and here's the facts. So, and I've talked about this before, so Rylands and Fletcher. So Fletcher had on his property a reservoir. It was made out of clay, it was earthen, and it failed. So the walls of the reservoir failed, and it flooded the property next door, and it went into the property next door was a coal mine. So it came onto the property, then went down into the shafts of the coal mine, right? The reservoir had been built by contractors, obviously on Fletcher's land, and the contractors were negligent. All right, so you see the tie between the two. So the contractors were negligent. They didn't build the walls of the reservoir very well. So the plaintiff's claim therefore depended upon what was deemed to be the strict liability for the escape of water. So when this happened, negligence law hadn't developed yet. All right, remember, negligence law has only been around for 120 or 30 years. This case predated that, so there was no law of negligence to rely upon. So it was the defined strict liability tort of the escape of water, the Rylance and Fletcher rule. Right, so the Exchequer Chamber, that just happens to be the level of court, in unanimous rule said this. I'll just read it to you. We think that the true rule of law is that a person who for his own purposes brings on his lands and collects and keeps there anything likely to do mischief if it escapes, must keep it in at his peril, and if he does not do so, is prima facie being at first glance, answerable for all the damage which is the natural consequence of his escape. So it makes perfect sense. They're talking about, the water, the dam breaking in the reservoir and flooding the coal mine. He can excuse himself by showing that the escape was owing to the plaintiff's default, or perhaps that the escape was the consequence of something major or the act of God. So there's the beginning of a defense to strict liability, if to a great degree it's out of the defendant's control. So the House of Lords, on appeal, basically introduced the concept of what is called the non-natural use of land. So it took the trial decision in Rylance and Fletcher and defined it and refined it to some degree to say basically that whatever flows from somebody's land to their neighbor's land has to be a non-natural use of the land, okay? So no liability would be imposed, for instance, the natural runoff of water from higher land to lower land, okay? Which, that could have been the case in Rylance and Fletcher, but it wasn't because the reservoir was a non-natural, man-made kind of thing. But if it had been, say for instance, it had a lake or some kind of a pond, and the walls of the pond or lake gave way and did the same thing, it flooded the coal mine of Rylance, right? Then there was no liability for that. So the House of Lords restricted this rule to non-natural uses of lands, basically. And that's what the court says here. The defendant collected water artificially, and therefore strict liability applied to this non-natural use of land, right? And that particular concept has played a central role in the evolution of this particular tort. So the two things you have to show, or the three things really, you have to show a non-natural use of land. Something has to escape from your land in a non-natural, as a non-natural function, and will do mischief or damage, right? So those are the elements of the tort. So non-natural has come to mean over the course of the development of the common law, something that's dangerous, extraordinary, special, and has no general benefit to the community. So if something is built that's non-natural, but it has utility for public purposes, then again, that's not going to be a tort. And we talked about that last day in negligence with respect to if a public authority, somebody who collects taxpayers' money for the benefit of the community, in some cases when they commit negligence, right, it's a defense because the utility of the use it overrides the nature of liability, right? As part of the common law, we have the decision of Rickards and Lothian. Again, these are British decisions, which dealt with the escape of water from a domestic plumbing system. All right, well, that's a pretty common kind of thing, right? And in that case, when it looked at, well, is that non-natural or not? It said that non-natural is a special use of land, bringing with it increased danger to others, and must not merely be the ordinary use of the land or such a use that is proper for the general benefit of the community. And it boiled down to that the one consistent factor in the Lothian decision with respect to non-natural use is that however this use is built on the land or comes to be on the land, it has to clearly create an increased danger, the danger being for your neighbors. All right? There are two general categories of non-natural use: land use that has a great magnitude of danger independent of the particular circumstances of what it is, right? And the land use that is not always dangerous, but can be in particular circumstances. right? So those are the two categories of non-natural use. So the first category includes lands that are regarded by the public, by you and me, as dangerous in and of themselves, right? So if somebody builds something dangerous, if we looked at it and say, Jesus, that's dangerous, right? Just looking at it, then that's the first category. So they include things like the storage of water in bulk, the manufacture and use of explosives, fumigation with poisonous gas. These things just make sense, right? Common sense. The storage of transportation of natural gas or propane, dangerous chemicals or gasoline, the storage or use of nuclear power, right? So, you know, for instance, the Darlington nuclear plant in Pickering, we talked about a couple of classes ago, right? That is a dangerous non-natural use of those lands, right? So there's no question that, you know, if anything escapes, radiation escapes, or anything that does damage to the neighborhood of Pickering, right, then the strict liability of Rowlands and Fletcher applies to it, okay? Even though it is for public use. So the way that dichotomy has been addressed is that the government has capped the damages, and we talked about this before. So in Canada, there's a $1 billion cap on damages. So that recognizes that, yes, this is a Rowlands and Fletcher dangerous non-natural use of the lands, but at the same token, we're not going to bankrupt the company because it is providing a utility to the public. So we're going to cap the damages, you know, at $1 billion. It used to be 200 million, right? So the second category includes lands that doesn't usually carry that kind of danger in the normal circumstances, right? So, you know, it includes, you know, danger that arises as a function of the use of the lands, but takes into account, you know, the particular use that it has and the circumstances of the time and place that makes something that isn't normally dangerous, dangerous, right? So in the Helchuk and Ratke, there's a farmer who sprayed herbicide on his land from an aircraft. Right? So this case is a little old because you can tell from the circumstances. So some of that herbicide drifted onto the plaintiff's land and damaged the plaintiff's crop, right? So the court held that the spraying of the herbicide in that manner was a non-natural use of the defendant's lands, and the liability was imposed, right? So these are the early days of, you know, for the most part, biplanes, basically sending herbicides, pesticides across the land. That was seen as unusual in those days, right? It's the early days of that kind of application of herbicide, basically. So the court emphasized that spraying herbicide from the air was an unusual operation at that time. It's not that unusual anymore, right? Planes I don't see a lot around the Sioux, but I mean, I raised my family, you know, in farm country. You know, the airplanes, you know, spreading herbicides and pesticides on farms is a pretty common kind of thing. So this particular rule really wouldn't apply in this situation any longer. So it changes as society changes, really. There was much less chance of drifting in the normal method of doing it because it used to be done by tractors, right? So it's been overcome by planes. So the emphasis on the normality, utility, context, and circumstances, you know, of the land in this second category of dangerous non-natural use kind of now blurs the distinction between strict liability under the Rowlands and Fletcher rule and the tort of negligence. All right, so this again is the evolution of strict liability being subsumed to some degree into negligence. So anybody who has an unusual use on their land, right, that wasn't in normal circumstances dangerous, but, you know, became dangerous and something happened and carelessly some harm was caused, then chances are highly likely that the lawyer who is suing on behalf of the plaintiff is going to use the tort of negligence rather than this second category of dangerous non-use, basically. Again, a special land use is dangerous because the circumstances and the place, the use of the land where it's found, right? The escape of something, this is another strict liability tort. The escape of something likely to cause mischief from land controlled from the defendant is always an element of Rowlands and Fletcher. And the two components are mischievous things and there's actual escape, all right? So most cases in this subset of strict liability deals with the single escape of a harmful element right? And that's what it used to be. It evolved over time, however, and now we're looking more like multiple escapes for things like toxic chemicals and refinery emissions. So that's very much environmental, right? Occasionally, Canadian courts have flirted with the idea of a responsibility for all losses generalized by ultra hazardous activities, right? But there still has to be an escape, right? So whatever is being used that has some relationship to the neighboring properties, it has to be hazardous, but it has to be, it just can't be contained on that property. It has to obviously flow elsewhere, right? For damages in the rule of Rylands and Fletcher, again, you have to have proof of harm, which is exactly the same thing in negligence. So there's no difference with that, basically. Most of the cases in Ryland and Fletcher deal with neighboring land and things that flow onto that land or under the land, as we already know. But it also can include things like chattels. So crops on lands, those are chattels, right? So doing damage, for instance, the airplane case meets that test of doing damage to chattels, because these are something that basically will grow on the land. While they're on the land, they're a fixture, but once they're cut and become crops, they're chattels, right? There are some long-standing commercial activities that bring rise to this rule. Things like mining operations, pulp and paper mills, dry cleaning, oil and gas industry. Basically, they have historically always discharged toxic elements into the environment, right? Mostly into rivers and streams and lakes. We know that already, right? At the outset, that conduct, when all these things started to be built in the 30s and 40s and 50s kind of thing, there was an ignorance of the harm being caused, right? The harm being caused wasn't seen to be something that would have a long-term effect, right? So it was seen to be what's called environmentally benign, right? And then it seemed to be basically any harm it caused was a cost of doing business. Current public policy, however, is much more sensitive to that. We know that. I'm going to show you a video at the end of the lecture on work, on damage done in Ontario to a First Nations water source. So I'm going to show you how that's evolved over time. So we're much more sensitive to this kind of damage to the environment. Okay. All right, mass torts. So mass torts, again, back to the video we just saw on Melflaquen, all right? So mass disasters, which give rise to mass torts, have been the experience in a lot of countries. So, basically the meltdown of nuclear facilities, that leads to mass torts, right? Just makes sense. That's an oil rig under fire, right? So, the dispersion of oil, and so the BP oil disaster 10 years or so ago now in the Gulf of Mexico caused tremendous damage. They couldn't put the fire out. They couldn't stop the oil from leaking out of the mine or the drill site. So every night in the news, you guys probably don't remember this, but every night in the news, you would be seeing underwater photographs of thousands of gallons of oil emanating into the Gulf of Mexico, which is a really important body of water, touching the coasts of Florida and Texas and Mississippi and what have you. So it was causing a tremendous amount of damage, right? There are three types of disasters that give rise to mass torts. Single event occurrences, which like the BP oil disaster or a nuclear disaster, basically. They inflict injury on a lot of people, but do so on a one-time event kind of basis, right? You have what are called serial injuries or creeping disasters. So that's something that's caused by the same product over a long period of time to a lot of people. So again, this is like I was talking about earlier with the using of asbestos in building products in houses and pharmaceuticals, not unlike Melflaquen, that are used over a long period of time. So it's a serial injury kind of thing. And then you have toxic damage, which affects persons and property over a given area. So now we're talking about landmass. All right. So the first category poses the fewest problems with respect to the law of torts, with respect to suing somebody, because causation isn't an issue, right? You're going to know when a nuclear power plant melts down, you're going to know that the owner of that plant, even if it's a government, is going to be responsible for it. So you don't have to worry about causation. You know, that's not something you're going to have to deal with, right? So as a function of that, consolidation becomes very easy. So all of the people who are damaged can come together in a mass tort action because the same facts have affected everybody. The meltdown of the plant has caused, you know, this not necessarily the same amount of damage, but the same kind of damage to everybody involved. All right. The second category, the serial disaster kind of things, the same product over numerous victims over time. Right. The fact, you know, the difficulty about that is that there are complexities in the tort itself, because it could be, for instance, a misuse of the product by the plaintiff or one of the plaintiffs. So that's going to be different from plaintiff to plaintiff. So it kind of makes a mass tort a little more complicated. The frequent latency of the injuries. This is a really big problem for this kind of injury, because, you know, some people don't know that they've been injured as a function of the long-term use of things like a pharmaceutical or asbestos. You know, you could be unaffected by it for a very long period of time before you're actually affected by it. So, you know, who joins this mass tort is a little bit troublesome, because it's not a fixed thing that happened at the same time to a lot of people. It happened to a lot of people over a long period of time in different ways. So that makes a tort kind of complicated. The third category of toxic or environmental torts, again, this is something going on to land that causes environmental harm. Then, you know, the problem with this is, in the tort concept, is the proof of causation. What caused this to take place? It's not always easy to determine that. It's not, again, like a nuclear plant melting down. All right. So toxic emission, right, often causes injury, but it has to compete with what's called background risks, which could equally have been causative, especially where the fallout is from a large area. So, you know, it's not always so easy to identify what is causing an environmental spill, so to speak, or the creeping of some environmental kind of action that affects a lake or a river. You know, it could be more than just what that one source of the toxin emanates from. So it makes it difficult, right? And you have to remember now that the basis of liability for these kind of things is still typically negligence, right? That's where it's evolved, you know, as far as that goes. So you have to contrast that with things where, again, strict liability makes more sense, things like defective products and nuclear accidents. So the kinds of environmental harm that spreads, and because of the difficulty there is in nailing down the cause and those kind of things, more often than not, environmental harms are seen as much as negligence as they are as strict liability torts. All right. So what does the law do about these kind of things? Well, the first thing they do is insurance. Right? Insurance is put in place by, you know, everybody who builds and operates uses that could potentially cause harm. Right? So they do that because, you know, that shifts the loss from them when that harm is caused to an insurance company. Right? And the great thing about insurance for those people who pay for it is that, you know, a number of people, you know, over a very broad spectrum pay for insurance and their premiums. So that shifts the risks from somebody who's caused a meltdown to a much larger community. Now, nuclear plants don't get insurance, right? It's just prohibitive. But any other kinds of use that are not quite so traumatic, there could be lots of people who have insurance, and you could take advantage of the spreading of that liability, basically. Then again, the magnitude of multiple losses in mass disasters will overtax the capacity of the insurance industry, and that's why they don't give insurance for those kind of things. All right. The public response has been to legislate caps on a lot of these things. So I mentioned about the $1 billion cap for nuclear power plants, but there are lots of caps for all kinds of possible damage that could take place. And the caps, you know, for instance, you know, most homeowners have a choice between a $1 million and a $2 million liability insurance policy for damages caused in your house. That would be, for the most part, for instance, somebody who trips and falls and breaks their neck. in your house, which could cause permanent injury. So your insurance company, your house insurance company, and again, the vast majority of people have house insurance, so the liability is spread amongst all those people who pay premiums. The insurance company gets that shifting of the loss amongst all those people, and they will pay up to $2 million in damage. If for some god-awful reason the harm caused to somebody in your house is more than that, so say the house burned down and people were killed in the house, right? And so that gives rise to liability that could rise to a very large sum. The insurance company is basically saying the cap is $2 million. So the plaintiffs will get that cap, that $2 million in their lawsuits. And if they are looking for more recovery in a lawsuit that involves these kind of things than that $2 million, they will go individually after the people who caused it. So the homeowners, are covered up to $2 million, and if somebody sues them for more than $2 million, it comes out of their pockets, which is a pretty difficult situation, as you can imagine, right? So again, those people who can't be properly insured are often driven into bankruptcy. Again, this happened to the asbestos industry, 20, 30 years ago. The problem with that is, of course, is that, anybody who was harmed by that industry, who had long-term damage to themselves, their lungs were damaged for the rest of their lives, those kind of things. If those asbestos factories have gone out of business because it's not such a profitable business anymore, then they have to rely on the public assistance. They have to rely upon, in Canada, fortunately, we have universal health care. But if this happened in the United States, chances are as great as not that you wouldn't have coverage. So, it all depends on where you live to a great degree, basically, all right? While it may sometimes actually be easier in practice to link a defendant's negligence with injuries resulting to more than just one person, there remain a lot of questions with respect to uncertainty given rise by the fact that there may be several possible actors that have been responsible for the injuries, and it's uncertain as to what exactly caused them. So this is, for instance, this would be in the case of product liability, all right? So where a number of pharmaceutical companies manufacture a drug, and the same drug could be manufactured in various versions by different pharmaceutical companies, and it turns out that drug is highly dangerous, in long terms, basically. So, the difficulty for somebody who is suing these companies is that, was it this drug company that caused the injury, or was it that drug company that caused the injury, right? With respect to maybe they both have something to do with developing the same drug. So, a plaintiff has a difficulty if they can't decide who to sue. Is it this company or that company, right? So we're talking about difficulties at tort, right? The way it's worked out is this: if there's more than two actors involved, there's a 50-50 chance that any one of those two was responsible, right? And so what has to happen is that in order to go after one company, you have to prove that they were at least 51% liable for the damage caused to get damages from that company. But if you can find that both are responsible, both contributed to it, then they will share the responsibility equally, right? So it's the law of contributory negligence. They will contribute equally to the burden that they bear. And remember, we talked about this last day, negligence, with the guy who shoots the gun at a guy who's shot in the shoulder. He dies, but not because of the shooting of the gun necessarily, but the intervention of the surgeon who negligently did the surgery. So both of those parties had to contribute to that claim for damage, right? If, again, the defendants exceed two and you can't ascertain, if one party was 51% versus 49%, then the case is a California decision of Sindel and Abbott Laboratories is the rule. Basically, that was a class action against 11 manufacturers of a generic drug called DES, and that was a synthetic estrogen by pregnant women to prevent miscarriages. All right, so a very common drug at that particular time. And what the California Supreme Court basically said is, because we can't tell which one of these 11 companies are responsible for what level of damage, then it basically said that the level of damages on a contributory basis that these 11 companies will pay is going to be premised upon their market share, right? So if one company has 30% of the market, one company has 20% of the market, and 9 of the companies have 5% of the market, 5.5% of the market, right? Then the damages will be paid 30% by one company, 20% by the other, and the other 9 companies 5.5% each. Okay, so it's pretty straightforward. A really important rule, because no, it wasn't a rule in tort that settled that issue before that particular case. If there's an, when the plaintiff is indeterminate, as in you don't know exactly, who has been hurt, you don't know whether the origin of the injury is attributable to the defendant's product or activity or some other unrelated cause, right? Then in the absence of direct proof as to who caused it, then you turn to epidemiological studies, which are used in this case. And what those studies do is they establish the causal relationship by comparing the group of people who've been exposed to the suspected agent with the general population, right? So this is where you're trying to narrow down the group of plaintiffs. The problem with that, of course, is that in accommodating the litigation of mass torts to procedural facilities using the legal system, it's not necessarily a neat fit, right? The more complicated it gets, the more complicated litigation tends to be, right? And so, in cases like asbestos claims, where there were hundreds of thousands of actions, or in cases like Vietnam, the Agent Orange, I talked about this earlier, with the defoliation of cases, there were millions of them, right? And so those cases, mass torts, became really, really complex and became, the models for mass litigation involving hundreds of claims, because that's the indeterminate plaintiff. All kinds of plaintiffs had different kinds of injuries lasting different periods of time, affecting their lives differently, right? So, mass torts, that's what they do. Okay, guys, so that's it for strict liability and mass torts. Now, the other PowerPoint that I had for you tonight is on the evaluation of damages for these kind of things, but I'm not going to go through the PowerPoint. I'm just going to show you some videos that basically give you a background on how mass torts, how they've caused damage, and how they've been dealt with, right? And then after that, we do the breakout session and we're done. So let's go back, and Grassy Narrows is what I referred to earlier. This is the First Nation in Northern Ontario, Kenora, that caused monumental damage 40 years ago.
For years, the people of Grassy Narrows were poisoned with almost every meal.
The Jones Road heads due north from Kenora, Ontario. And for 40 years, journalists like me have been driving up it. Driving past what seems like untouched, pristine Canadian Shield. But for generations here, a silent killer has been at work.
What we have done to the Ojibwe people here falls little short of an act of genocide.
Even if the chemical plant in Dryden were to stop production or change its technology and not a single ounce of new mercury were to enter the river system, it could take 100 years for the present mercury to disappear.
Among the people here, there's a growing sense of the dangers of mercury poisoning.
Methylmercury poisoning attacks the central nervous system. Its effects are devastating.
In a country with no shortage of troubled reserves, Grassy Narrows stands out. Unemployment has hovered at 80% for decades. Alcohol abuse, suicide, violence, all problems here, though things are far better now than they once were. But by far the worst thing this First Nation of 1400 has faced is the mercury.
This is Matthew Beaver. At the time of our original testing, he was the one at the highest level of mercury.
That's former Chief Bill Fobister. He was in his mid-20s when it all started.
During the 60s we were in full bloom. Fishing, guiding, everything that we did, and we thought everything was okay. But it's not until that we're seeing some of our fish acting weird and dying off. That's when that there is something wrong.
Something certainly was wrong. In March of 1970, the Ontario government found the water was poisoned. The Reed paper plant upstream had slowly dumped 10 metric tons of mercury into the river system. The mercury poisoned the fish, and the fish poisoned the people. The symptoms were dramatic, and many were sick. Many are still sick, including Bill Fobister.
My symptoms is my numbness and loss of sensation and my vision. My speech is kind of getting pretty sloppy. My taste, I lost my taste. I lost my smell. I can't smell anymore.
But the mercury didn't only destroy people's health. It wrecked the local economy too. The commercial fishery closed. Guiding for tourists dried up. In 1983, CBC reported an epidemic of violence and suicide in Grassy Narrows.
The federal study said that 3 of every 4 people buried here died violently. The
chief at the time was Bill Fobister's cousin, Steve.
I don't think, it's right to say, look at, you don't have to go trapping. You can live on welfare.
I heard from Bill that Steve was now sick. I found him at his house, a prisoner to his own body.
My whole nervous system is out of whack. And, I can't barely walk. Then, I have to hold my jaw tight because my muscles are practically gone.
Steve believes he's sick because he was a fishing guide. He ate what he caught, even after the mercury was discovered.
We had to do this in order to appease our guests that the fish was okay. The tourist camp owners encouraged us to do that.
When the mercury was initially discovered, the government denied it was making people sick. Until a doctor from Japan, an expert, concluded poisoning was widespread in Grassy Narrows. Dr. Masazumi Harada returned to Grassy Narrows this past month to follow up.
How are you?
Steve Fobister went to see him.
He said, you have some kind of a metal poisoning, and closest definition to his examination came to, it's gotta be mercury.
But as the older generation continues to suffer from mercury poisoning, and as their symptoms continue to get worse, it's now clear they're not alone.
And I only have one granddaughter. She is the one who kind of possesses violent seizures.
The mercury has poisoned some of the younger generation, too, including Steve's granddaughter, Catherine. She's now 10. She's had seizures since she was very young. She's developmentally delayed, too. Sherry Fobister is Steve's daughter and Catherine's mom.
Like everybody said that, this problem was gone and like it happened in the 60s, and then, there's this doctor telling me that, my daughter has, all these medical problems she has, and that's the cause of it. And I don't know, like, I'm still shocked to this day. I still don't understand.
Sherry ate fish when she was pregnant. And though over the years the levels have gone down here, a study done just last year shows many of the fish still have mercury levels Health Canada says are unsafe for frequent fish eaters and are especially unsafe for pregnant women. The fish with the highest level of mercury is also the most popular, pickerel, also called walleye. Did you eat fish when you were pregnant?
Yeah, it's like, for us, it's like a part of life, you know, and you know, I love eating fish. It's a delicacy, and you know, it's part of our lifestyle, and I don't know, I still eat it to this day.
Did anyone say to you, don't eat the fish when you're pregnant?
No. Nobody told me that.
Particularly the pickerel, the walleye?
Yeah, that's my favorite.
Dr. Harada, who I interviewed in Winnipeg before heading to the reserve, told me the levels of mercury currently in grassy narrows are still cause for concern.
今まで全然食べてない人ならね、はっきり言って妊娠お腹の中の赤ちゃん以外は起こらないと。
And for people from grassy narrows who aren't pregnant, it's still unclear what level of mercury is safe for long-term exposure.
単純に言うとね、例えば全然今まで汚染されてなかった人がグラッシーに来て、そして今の魚を食い続けても、今のレベルだったらこの人に長旅になることはないんです。ところがグラッシーの現実は前からずっと食ってる人ばっかりなのよ。それをね、ごっちゃに質問するかわからなくなるんですよ。
But back in grassy narrows, that hasn't stopped people from fishing or from eating fish. Out on the lake, I met Bill Fobister's son-in-law, Larry Kiwatin.
I usually just eat maybe 5 walleye a month due to mercury in the fish.
He's only catching northern pike today, and he's not happy about it. He wants walleye. Larry, did anyone tell you that the walleye is the fish with the highest mercury concentration?
No, that's kind of news to me.
In 1985, after a 15-year battle, the Ontario government and the paper company agreed to a financial settlement with the residents of Grassy Narrows. For those judged to be affected, monthly compensation was and is paid out. Steve gets $250 a month. Bill gets $350. Catherine gets the maximum benefit, $800 a month, held in trust until she turns 18.
They just gave her compensation, like it's gonna make things better. What about her? You know, how she's been through so much, you know, for a little girl. And she deserves to have a good life and be healthy.
So another journalist comes and another journalist goes. 40 years after the first came to Grassy Narrows. Another journalist drives down the Jones Road. Only 60 more years before the mercury's gone.
Tomorrow we will.
All right, guys, we're gonna do something different. Before I move on to the short videos on the BP oil disaster, I thought maybe some of you may want to have some comments about that particular piece because it's pretty powerful. Shivani, you had your hand up?
Yes.
Sure.
Globally, like, mercury is found in fishes, not only like Canada. But what is the cause of that, though?
The cause of what? I'm sorry?
Mercury found in fishes, like, globally.
Well, it's a byproduct of the processing of pulp and paper. It's part of that chemical that is used in that regard. So that's at least here, and probably the same everywhere else. That's how it got into the water supply. All right.
Yeah.
Go for it.
So, seeing that in recent years, the government and the company reach a settlement, and the persons are being compensated per month. So know that they are aware that the water, or the fish in water, is not healthy for consumption. What are they doing? Why continue to eat the fish? That may be an hard question to answer. Them living in that area, as the female says, that's a part of their life and stuff.
Yeah, it's a cultural thing.
Yeah, but beyond that, no, this is where your health comes in play. I think there should be greater awareness or greater input from the government too, maybe federal level, in trying to perhaps relocate those persons or educate them more. Because more person, I don't think everyone there, as someone that was featured in the film, truly understand the harm of consuming the fish there. And I'd expect more of a awareness from the government. Now that it's public knowledge, they have reached a settlement. So what next? Because money has been paid, but persons are still consuming this fish. So it's almost like there's no solution. The issue has not been resolved on the part of the community.
Yeah, I mean, you're absolutely right. I mean, it's very difficult because if these members of the First Nation willingly choose to ingest something that is dangerous, and they know it's dangerous. Grassy Narrows has been in the news, for 40 years, right? It's not a secret that the fish are the white fish particularly are dangerous. So it's what are you going to do? To some degree. Tyler?
Hi. Yeah, I was just gonna make a note that, and it's essentially the same as he just said. I was just surprised by the lack of awareness by the community, as well as the lack of regulations on behalf of the government or any or community or even the lack of regulations to the businesses that are causing these damages. I was just surprised at pretty much how laid back the whole situation was treated, I guess, one way to put it. I was also surprised at the amount of compensation being received. I'm not sure if that seems entirely just or reasonable, but I mean, I guess overall, I just think this whole situation is being treated very lightly as far as regulations and compensation.
We have to remember, and this is a couple of lectures ago, but I mean, the Grassy Narrows and the pulp paper mill putting that poison into the river took place in the 1960s. Remember that the environmental movement didn't start in Canada until the 1970s. The first Canadian Environmental Protection Act was 1973. Same thing for the provinces. So when these pulp paper mills were built, and it's really any kind of resource extraction company. Pulp and paper is a resource extraction, right? It's timber. Nowadays, and for at least the last 20, 30 years, environmental assessments are required before you get the plants built, right? Before you get a permit or a license to build those kind of plants. So all of the precautions, so exactly this kind of thing doesn't take place, is supposed to be in place. It's the command control toolbox again. You command by way of environmental assessments what they can and can't do, and then you basically monitor them to make sure they don't. So this has been really famous for so long because it occurred. It initially started occurring at a time when there was virtually no environmental regulations. Right, it was before anybody even paid attention to it. But now everybody looks at it and goes, "My God, how could that have happened? And how can it still be causing damages and not being, fully addressed?" And that's, it's because the settlement that the government entered into Abitibi and the First Nation, they had to sit down and they all had lawyers and they all, resolved it according to the best way they could. But, it's certainly not perfect. Lexine?
Yeah, I was just saying that, like, it's really sad that especially the fisherman is like well aware of like the poison that is in the fish, and he still has like but then again, you can't really take this away from him because it's like one of their main sources of food.
Yeah, exactly. Their livelihood depends on it to some degree.
Yeah, it's just sad.
Shivani, you had your hand up again, or is this still? All right, you're up again?
Yep.
Okay.
So now we're all agreeing that them consuming the fish is the livelihood, it's a culture. So where do you go from here? If they keep on doing this, the next 40 years, when another generation comes out, it will be a continuation of things. Person gonna eat the fish and die, and the community is gonna erase themselves. So what's the solution, and why are they reporting on it then, seeing that maybe for them, the issue have been dealt with already. So I guess other than awareness, what purpose does the highlighting serve? Because it was raised, the government compensate, the water will always be there, the fish will always be in the water. But now that they know, they're still consuming it, which means that their health is deteriorating. Young kids, the younger generation are consuming it. These adults now know that the fish is bad, and the young kids in the community is eating it. So why are we talking about it then, if it's not to drive change from the community at this time? I don't know.
Well, the only thing positive that came out of that was that the Japanese doctor who was there decades ago and returned, he seems to feel that there's been some degree of reparation to the river, the waterways, because he thinks that people won't necessarily get sick going forward, certainly to the degree there was before. So and what will happen over the course of time, I mean, 40 years is still, 50 years is still within people's memories, people's lifetimes. So, but 50 years from now, right, if there's, if it's another 50 years of nothing going into the river, nothing contaminating the fish, it'll just become a memory. And whether the First Nation is still there or not depends. It's totally up to the tribe, the band actually. But it'll dissipate over time. But obviously a lot of damage has been caused in the meantime. And that's just my guess. But I think it's probably the way it's going to happen. Anybody else have any questions about that? Really famous instance of environmental harm on a mass scale. All right, guys, so we're going to go back to evaluation, and I'm just going to show you a couple of brief videos on BP oil because it was such a disaster and not that long ago.
Yesterday was the 10-year anniversary of the worst environmental disaster in U.S. history, the Deepwater Horizon oil spill. That began yesterday. And over the past decade, scientists have been working to understand the impacts of that event and what lessons can be learned from it. 4.9 million barrels of crude oil spilled, 68,000 square miles of ocean polluted, 1,300 miles of shoreline impacted. 11 lives lost, 170,000 dead sea turtles, 800,000 birds killed.
So many animals were impacted. It had a devastating impact on marine life. Scientists who studied the spill described large swaths of the ocean floor near the site as a toxic waste dump. Many impacts are still occurring today, and many marine mammal populations may take decades to recover. The fisheries closed, people couldn't fish, people couldn't buy seafood, and that had catastrophic impacts to the seafood industry as a whole. Nearly $1 billion lost to the seafood industry.
It's been 10 years. 10 years seems like a long time. What have we learned in that time period from the disaster, and what changes have we made as a result of those findings?
Sure. I mean, today, offshore drilling remains dirty and dangerous, just as dirty and dangerous as it was 10 years ago.
How much more likely does this make us to seeing another disaster just like the one we saw 10 years ago?
As industry drills in deeper places and places that are farther from the shore, these areas are much more risky. And so we could even be at greater risk of a spill like this from happening today.
But do you think we've done enough?
Unfortunately, no. It's terrifying that this could still happen again. And instead of learning from the lessons, President Trump is talking about more drilling, less safety. That's a real recipe for disaster.
As part of BP's penalty, the company financed $500 million over 10 years for recovery and research. Much of that happening here at the University of Miami's Rosenstiel School of Marine and Atmospheric Science.
We are now better prepared to understanding what's going to happen in the next oil spill. And I want to make the point here that it's not a question about whether we're going to have another oil spill or not. It's a matter of where and when that's going to happen. It will happen. When that happens, we're prepared. We know a lot more than we did going into the Deepwater Horizon oil spill.
Now, Dr. Grossell and his team at the University of Miami have been a part of that Deepwater Horizon research from the start. So later this week, we're going to show you what they've learned in the decades since that disaster. Shelley, I'll send it back over to you.
Angie, wow.
Yes.
BP continues to break records, but not in a good way. Theirs was the biggest ever offshore oil spill. Now BP will pay the biggest ever criminal fine in U.S. history as part of a $4.5 billion settlement. The oil giant has pleaded guilty to 14 criminal charges relating to the Deepwater Horizon disaster, which killed 11 workers and fouled the Gulf of Mexico with millions of barrels of crude oil. Here's Jane Deeth.
The explosion in the Gulf of Mexico claimed 11 lives, and for 87 days, millions of tons of oil spewed into the sea. The US government was threatening to take BP, which owned the well, to court. Today, the Justice Department announced the oil giant had settled the case by admitting guilt and paying a penalty of $4.5 billion.
The department filed a 14-count information charging BP with 11 counts of felony manslaughter, 1 count of felony obstruction of justice, and violations of the Clean Water and Migratory Bird Treaty Acts in connection with the Deepwater Horizon oil spill that began in April of 2010.
The chief executive issued this contrite statement.
All of us at BP deeply regret the tragic loss of life caused by the Deepwater Horizon accident, as well as the impact of the spill on the Gulf Coast region. We apologize for our role in the accident, and as today's resolution with the US government further reflects, we have accepted responsibility for our actions.
So the oil companies avoided a criminal trial with the $4.5 billion settlement. But that could just be a fraction of what BP may have to stump up for the Deepwater disaster.
Because the company also faces a sea of civil claims for compensation, from authorities that had to clean up beaches to fishermen whose businesses were ruined. The company has set aside $38 billion to deal with all of that.
But writing checks won't get BP back to where it was before Deepwater Horizon. It could take years to clean up its image with the public and investors.